Please be seated. We are sure.
Thank you very much, all. We are back and we apologize for being a wee bit tardy. All right, so the CLRV, you have the floor. May we hear you, please?
Thank you, Madam President. Madam President, Your Honors, together with Paulina Mesida, Francisco Cox, Joseph Manoba, and Paul Bradfield, we appear before you today to speak on behalf of the 5,795 victims authorized to participate in the present proceedings as of the 12th of August. It is an honor to represent these women, men, and children whose lives were destroyed by the acts of Joseph Kony and his Lord's Resistance Army, or LRA. The victims have waited for more than 2 decades for this moment. They have waited for more than 2 decades for their pain to be acknowledged, for their loss to be recognized, for justice to be done in their name. All these victims have waited long enough, Your Honors. Some have been waiting since July 2002, when the LRA's first attacks hit their villages. Some will not live to see the conclusion of these proceedings. But they all deserve to know that their suffering has not gone unnoticed, that the world has heard them, and that those responsible will be held accountable. And amongst them, the suspect, Mr. Kony. Make no mistake, however, the number of victims represented in the present case is only a small proportion of those affected by the crimes charged against Mr. Kony. Madam President, Your Honors, victims are waiting for explanations, and this wait has gone on for far too long. Without an explanation, victims will not be able to overcome the tragic events that victimized them. Yet, forgetting is necessary for their recovery. But this forgetting is impossible as long as they do not understand why they, or their brother or sister, their son or daughter, their husband or wife, were abducted, forcibly recruited into the rank of the LRA, raped, tortured, murdered, why their properties were looted, burnt, why they were forced to live in the bush or in IDP camps. The sadness, the void left by those who have disappeared, the anger and fear of dying is so deeply ingrained in them that it still affects their life every day, preventing them from sleeping, working, participating in the lives of their community. In short, Your Honors, from rebuilding their life and moving forward. These emotional and psychological wounds are not just consequences of the crimes. They are the very markers of the trauma these victims experienced and continue to experience to this day. The families of the missing victims, for their part, are unable to mourn until they receive an explanation about the fate of their loved ones. and the reasons for their suffering. Our clients' healing process requires recognition of the crimes they have suffered, judicial determination of the reason why they were victimized, and the punishment of those responsible for these abuses, including Mr. Kony. Madam President, Your Honours, some of the facts we will deal with over the coming days are not unknown to this court. As Mr. Ongwen, brigade commander of the LRA Senior Brigade, was convicted by this court for a total of 61 crimes, comprising crimes against humanity and war crimes committed in northern Uganda between the 1st of July 2002 and the 31st of December 2005. Indeed, a number of crimes and events described in the amended document containing the charges against Mr. Kony are the same as those charged against Mr. Kony, as the same as those for which Mr. Ongwen was convicted, and share an important number of similarities, including the temporal and geographical parameters. This is in particular the case for the charges in relation to the 4 attacks on IDP camps, namely in Pajule, Odek, Lukodi, and Abok. The same holds true in relation to the sexual and gender-based crimes and the war crimes of conscripting and enlisting children under 15 and their use to participate actively in hostilities. This being said, Madam President, Your Honours, it is important to recall that the charges brought against Joseph Kony go further than those for which Dominic Ongwen was found guilty. In addition to the charges common to both cases, the prosecution now charges Kony with inducing rape as a distinct offence, and it characterizes several gender-based crimes, namely rape, sexual slavery, forced marriage, and forced pregnancy as acts of direct perpetration by Kony himself. Furthermore, the charges extend to new incidents, including the attacks on Luala Girls' School and on the Abia and Barlonio IDP camps, which were not part of the Ongwen proceedings. As a result, some of the victims we represent participated in the Ongwen case, which was predominantly focusing on the Acholi community, mostly leaving aside the Teso and the Longo communities. But the confirmation hearing in the present case is a unique opportunity to finally acknowledge the full extent of victimization in northern Uganda, taking into account not only the Acholi region, but the 4 regions affected by the crimes committed by the LRA under Kony's command, namely the Lango, Acholi, Teso, and West Nile regions. Madam President, Your Honours, although the victims deplore the absence of Mr. Kony and are fully aware that their fate is intrinsically linked to his arrest, they consider the prison proceedings to be of crucial importance. Indeed, although they understand the painful reality that without the arrest of Mr. Kony, their efforts may ultimately be in vain, they nevertheless regard this hearing as a meaningful step in the right direction and are eager to contribute genuinely to the pursuit of justice. They also believe that the confirmation of charges hearing will renew the commitment of states to locating Mr. Kony and ensuring his surrender to this court. Your Honours, the role of victims in the proceedings is not to bring charges against the suspect. This responsibility rests with the prosecution. Rather, victims participate because they can play a vital role in establishing the truth. They indeed shed light on facts in a distinct yet essential manner, contributing to the pursuit of judicial truth, which lies at the very heart of these proceedings. Through their accounts, the victims confirm that the crimes set forth in the amended document containing the charges were not isolated incidents of war or random acts of violence. Rather, they were the result of a deliberate campaign orchestrated at the highest level of the LRA, a campaign designed to terrorize civilians, to sustain the LRA's operation by force, and to shatter communities so completely that resistance would become unthinkable. Madam President, Your Honours, by sharing the harms they endured and the trauma they continue to suffer, victims do more than sharing their pain. They offer powerful, significant evidence that these crimes happened and that they left deep, lasting scars. The charges laid before you speak of murder, enslavement, abduction, sexual slavery, rape, cruel treatment, pillaging, and forced recruitment of children into the ranks of the LRA. Before my colleagues Paulina Masida and Paul Bradfield provide a more in-depth analysis of the charges and their impact on the victims tomorrow, let me, Madam President, Your Honours, briefly attempt to give these charges a human dimension. It often began in the dead of night, the silence broken by gunfire, the screams of neighbors, the sudden terror that the LRA rebels had come. Victim A/4000/11 was only 12 when they came for her. I quote, "I was 12 years when I was abducted. 2 of my brothers were killed in my presence." That is how a childhood ends, with the loss of family and the forced march in the bush. Other victims were taken from places meant to protect them: schools, homes, churches. Victim A/20068/24 recalled, I quote, "I was taken from school. I was forced to cook, to carry loads, and later to live as the wife of a soldier. I had no choice." No choice, Madam President, Your Honours. Those words appear again and again in the account of the victims. They had no choice when they were forced to watch killings. They had no choice when they were made to kill. They had no choice when their bodies were turned into tools of war. And they had no choice when they were given as wives of LRA commanders. The abduction served a purpose. They were not spontaneous acts of banditry. They were part of a system designed to feed the LRA's ranks with new fighters and to provide its commanders with labor and sexual slaves. The prosecution's evidence will show this. The victim's account confirms it. Victim A/4001/11, taken at just 11, told us, I quote, "I was abducted at about 11 years old. I had to become a wife to one of the commanders. But, Your Honors, she and countless other abducted girls were not wives of Kony and LRA commanders. They were children enslaved, subjected to sexual violence day after day, their humanity reduced to the whims of men who treated them as property. The violence reached far beyond those who were abducted. Entire villages were wiped out. Survivors speak of homes torched, of livelihoods erased, of loved ones killed before their eyes. Victim A/20013/24 summed it up in stark simplicity. I quote, "All our huts were burnt." Another victim, A/20014/24, carries a loss that words can scarcely hold. I quote, "The rebels shot at me, forcing me to throw my baby down to run for my life. I still do not know where my child is." As for the daughter of victim A/20012/24, she was shot dead by the LRA rebels while still on her mother's back. This is what the charge of attacks against civilians mean when stripped of legal terminology. A mother forced to abandon her baby to survive. A baby killed while still on her mother's back. Madam President, Your Honors, the cruelty was unrelenting. It thought not just to kill, but to break the spirit. And indeed, the crimes committed by the LRA under Kony's command were committed deliberately to spread fear and enforce obedience. And, Your Honors, one might ask when the fighting ended. For many of these victims, it never did. They still live with the physical injuries, with the nightmares, with the stigma that followed them home. The girl who returned with a child conceived in captivity. The boy treated as a perpetrator rather than a victim. The man who lost everyone he loved. Victim A/45006/25 put it blankly, I quote, "My mother was caught and killed by the rebels. I have no family left. I live only with the memories." That is what remains, Your Honors, memories and pain. Victim A/45845/25 summarized the ordeal of the civilian population as follows. I quote, There were so many people killed, many children as well, and pregnant women. The LRA killed my mother, cutting her on the back and then on the neck. I saw our house burning. My father was also killed during the attack. My elder brother and sister were burnt in the house. I had to carry on my head the beans and posho. It was very heavy, and I slowed down. I was bitten on my head by the LRA rebels with the butt of a gun for this, and I started bleeding. I was walking barefoot. Children had to receive training. I was bitten 50 strokes on my lower back as a way of induction into the LRA. Other children were as well given the same treatment. It was very painful. I cried. I was forced to beat an adult on the head using a stick, and he died. I suffered a lot during my abduction. I did not eat and sleep properly. I had to do heavy tasks. I witnessed very bad things, and I was obliged to do bad things to other people. When I was abducted, I was going to school, and I had a future. Now my dreams are gone. And still, Your Honors, after everything they have endured, victims are here. Their presence speaks of resilience, of courage, of hope. They have found the strength to raise their voices, not to seek revenge, but to reclaim their dignity, to be seen, to be heard. They ask this court to name what happened to them for what it truly was. Crimes of the highest gravity, crimes committed with intent, crimes designed to terrorize and destroy. But they were not destroyed, Your Honors. Today, they ask that Joseph Kony be named clearly and without hesitation as the one responsible for their suffering. They ask you, Madam President, Your Honors, to confirm all charges against him, and in doing so, to affirm that their suffering was not vain, that the truth will eventually be acknowledged, and that accountability will prevail. Your Honors, the participation of victims in the hearings that opens today and in proceedings before this court more generally is essential. It serves as a powerful reminder that justice is pursued on their behalf to protect future generations from atrocities that defy imagination and deeply shock the conscience of humanity, and to ensure that the most serious crimes of concern to the international community as a whole do not go unpunished. The confirmation hearing in the present case and your subsequent decision will not undo the past. It will not bring back the brothers killed before the eyes of a 12-year-old, or the child torn from her mother's arms, nor erase the suffering inflicted on the victim by the LRA under Kony's command. But it will tell these victims that what they endured mattered, that justice can reach even the most powerful perpetrators, that impunity ends here. And, as already been stated, it may also reinvigorate states' commitment to locating Joseph Kony and ensuring his surrender to this court. That is why victims are participating in these proceedings. That is what they ask of you. I thank you, Madam President, Your Honours.
Thank you very much. The defense, you now have the floor to give your opening statements.
Your Honours, on the 21st of June 2024, I was assigned to represent the interests of Mr. Joseph Kony in a confirmation of charges hearing to be conducted in his absence. To assist me in that task, I assembled a team which was comprised of Ugandan lawyers and professionals and lawyers with expertise in international criminal law. It has been the greatest privilege of my career to act in this role, but simultaneously the most difficult mandate I have ever accepted. It's important that the public knows and understands the stance we have taken in these proceedings and what steps we have taken to fulfill that mandate. We have argued publicly, including before the Appeals Chamber of the International Criminal Court, that we consider these proceedings not to be consistent with the ICC's statutory framework. We have also collated and presented voluminous testimonial evidence from the leaders and people of northern Uganda who believe them to be misguided, harmful to ongoing repatriation and reconciliation efforts, and divisive. The court's decision, both in terms of legality and whether this is all a good idea, was to proceed. And today, we are here on what is undoubtedly a milestone for the court, the first confirmation hearing of a suspect who has never appeared, with the chair at the back of the courtroom sitting empty. It is also important to understand how that empty chair has impacted the defence preparations and how it informs and limits the position that we will be taking in these proceedings. I will briefly top and tail these opening remarks. The body of them will be delivered to you by Ugandan voices. And if I may be permitted one digression, it is no less than my responsibility to convey my thanks to the registry, and in particular the travel unit, who, when all appeared lost last Thursday, obtained visas for my two colleagues to be here today. We've privately emailed them to that effect, but sometimes public thanks are merited, and in these circumstances they are. In due course, you'll hear from Counsel Lillian Beatrice Ateem, who will briefly place these proceedings within their current and proper Ugandan context. Firstly, however, you'll hear from my colleague, Counsel Jeffrey Boris Anyuru, who lived through the events of the civil war in northern Uganda and still lives there. We requested exceptionally that he be permitted to address you in a choli, and have to confess that we were both surprised and disappointed to find that that met with opposition from the common legal representative of victims. Nonetheless, the Chamber kindly permitted him to speak on this occasion in a language which is primary to most of the affected community in northern Uganda. And without more, I will give him the floor.
Thank you, Councillor.
Thank you. My name is Geoffrey Boris Anyoro. I'm a lawyer in Uganda. I would like to thank the court for accepting me to stand in front of it and say a few words. In this opening statement, I would like to state thus far to the judges. As far as the population of Uganda is concerned, those in northern Uganda, in particular in Acholi, in Lao, and in Teso, and also Joseph Kony, if he's actually following these proceedings at the moment. The proceedings that are currently ongoing are not trial proceedings. In the end, nobody is going to be sentenced, nobody will be sent to prison. And I state this with sadness that nobody is going to get reparations for any of the suffering they went through. Even though they do confirm the charges, it's not going to be, Joseph Kony is not going to be tried for them. If at some point he is arrested and brought to this court, and I doubt that will ever happen because at the moment Uganda itself wants to initiate proceedings against him. But if ever he is brought to this court, then he has the right to request for a trial again so that the court can actually come out with the ruling. For all the people who have suffered, reparations or any other form of payments is not going to happen immediately. It's going to take time. It's going to take a long time. Even though the court confirms the proceedings and Joseph Kony is arrested, if he is tried, if he is sentenced, and reparation orders are issued, the victims of these the victims in the current case will not receive the reparations immediately. Indeed, in 2025, the reparations proceedings are still ongoing, even after reparations orders were made in the cases of Lubanga, Amadi, Ntaganda, and Ongwen. Moreover, the trust fund does not have the money to pay for the reparations where reparations orders have been made. We, the people of Uganda, know that we are still waiting for the reparations proceedings from the Dominic Ongwen case. We have to remember that the confirmation charges is only a small part of these proceedings. Joseph Kony, they're still looking for him. He's still out at large. There's a warrant of arrest against him, but he's not been arrested. But if the person is not here, if the person is not present, then these proceedings are just going to end without going any further. Most of the people in Uganda are listening to how the proceedings are going. They are waiting for witnesses to come forward. This is not going to happen. Confirmation charges in other cases are for somebody who is leading the proceedings, but from the prosecutor. But in this case, it is the court has to hear from the prosecutor and from the defense. But without any other proceedings, nothing will go further. With respect to these proceedings, the prosecution has not found any information to continue with these proceedings. Look, the prosecutor has shown everything that happened. They showed everything that happened in this court about 20 years ago. These things show our brothers and sisters in northern Uganda who were suffering, who had emotional and psychological problems. And we have a feeling that these showing of these pictures, showing these photos that the prosecutor has shown will cause more harm. It will re-traumatize them because they are seeing their relatives, they are seeing their brothers, they are seeing their sisters. This will cause them post-traumatic disorder. This is going to be shown to people, and anybody who wants to watch these photos or the pictures that were shown by the prosecutor will be able to see them again. Anybody who wants to see those the photos will be able to go to the computer, switch it on, and watch those photos. And without receiving any information from the people who were aware of it, we will not know whether these things actually happen. We do not know whether we'll be able to hear from these people. As the prosecutor decided to show these pictures are going to have terrible repercussions on the people in northern Uganda who are seeing these photos. We should be aware that these proceedings are going to take a very short time for things that happened for a very long time. The people who suffered, the people that the lawyers in this court are alleging suffered from harm are only 5,795. The harm that they suffered has to be looked into and they have to be paid. But we have to be aware that the number of these people is minute if we take into consideration the conflict in Uganda that started in 1986 and ended in 2005. We should also be aware that most of the victims are not going to get justice from these proceedings from the court, because the court in effect has a temporal limitation, looking at crimes that happened from July 2002 only, whereas some of the things happened prior to that. Most of this court is
Ben.
in the letter that Uganda sent to this court. The court Uganda did not say that it does not have any interest or that it is not able to try Joseph Kony, but Uganda asked the court to help it to arrest Joseph Kony with the help of the Americans and other African countries. It took 20 years, and Joseph Kony has not yet been arrested to date. Right now, the prosecutor would like to show that the current proceedings are going to enable him to arrest, does the prosecutor think the current proceedings are going to enable him to arrest Joseph Kony? If it took 20 years before Joseph Kony was arrested, does he think that he is in a position to arrest Joseph Kony right now? This is a really important question. As somebody who comes from northern Uganda and someone who grew up during the conflict and somebody who is also part of the proceedings, the traditional proceedings that are going on in Acholi, to ensure that those people who are coming back home are welcomed. And throughout the duration of the conflict that happened in northern Uganda, but not only from 2002 to 2003. To date, we have not yet received any information as to why the court is continuing with these proceedings. Why has the court decided to open and restart these proceedings, and only part of the proceedings, when this actually relates to a minority of the people who, a minority of the perpetrators, leaving out a number of perpetrators. This, in northern Uganda with other people, they have forgiven or have forgotten, trying to forget. Uganda has come up with means to stop the discrimination that happened among people, and we are very proud. I'm very happy for the time that have been given to speak to the court, so I'm going to give time to my friend Liliana Tim, a lawyer from Uganda, to continue from there. Thank you.
Your Honours, it's a great privilege and honor to appear before you today to address questions of such importance to my country, particularly to the communities of northern Uganda. Excuse me. You've heard from my colleague Boris from the north. I am from the Teso region, but I'll address this court in English. In my brief remarks, Your Honours, I wish to highlight the broader context of these confirmation proceedings and how their outcome could impact on the overreaching process of transitional justice that we have painstakingly built in Uganda for Uganda. Under the Rome Statute and international law, the primary responsibility for investigating crimes committed in Uganda rests entirely with the national authorities. This responsibility aligns with the broader needs of transitional justice, which can only be accomplished by Ugandans themselves. Over the last 20 years, Ugandans have done both. They have investigated the alleged LRA crimes and have also implemented broader reconciliation strategies. Ugandans have done this by passing the International Criminal Act of 2010, which incorporates all the Rome Statute crimes into the domestic law. This followed the establishment of the International Crimes Division of the High Court of Uganda in 2008, specifically mandated to hear international crimes and terrorism crimes. The ICD recently completed the trial of an LRA commander, Thomas Koyelo, for crimes spanning the LRA's entire period of activity. Victims participated and a substantial reparations order was issued in their favor. In parallel, Ugandans implemented the Amnesty Act of 2000 to facilitate the return and reintegration of lower-level commanders, rather fighters, who surrendered voluntarily, and these include members of Joseph Kony's family. The community, including victim communities, largely support this reintegration, of course without diminishing the importance of justice and reparations. The National Transitional Justice Bill, now before the Ugandan Parliament, aims to establish a war crimes reparation fund for all victims of the civil war, not just those from specific cases or time frames. Meanwhile, the reparations award in the case of Dominic Ongwen has created bitterness and disappointment among those who did not qualify as victims, and very high expectations and growing impatience amongst those who did. And this is the context in which these confirmation proceedings are taking place after 20 years of dormancy. This context is highly relevant to the arguments the defense will make in its submissions. But ultimately, this court can only be a small part of the larger project of transitional justice needed to ensure everlasting peace and reconciliation. Of course, the defense's requests not to hold this hearing have since been rejected, and so the proceeding is taking place. These expressions remain relevant so that the people of Uganda can fully understand the context in which these current proceedings are taking place and the position the assigned counsel has taken. Over the past year, the defense team has had the privilege of months of exchange with the people of Uganda, especially those from the affected communities. As a team, we have seen how the country is trying to heal and pull together after the upheaval of 20 years ago, thriving in some ways and still hurting in others. From our filings, we have met political leaders, cultural and religious leaders, victim groups, NGOs, judges, lawyers, returnees, and many ordinary people. We've collected their views on the state of the nation, how best to expedite these historical events, their opinions on the ICC, and this process. Unfortunately, Your Honors, the words self-interested and experiment were repeatedly used to describe these proceedings. Ugandans find it hard to understand how these particular in absentia confirmation proceedings serve the interests of their country. A small fraction of these views have, totaling to nearly 100 pages of statements, were presented as testimonials to the pretrial chamber for consideration. The public can access the same on the court's website under filing number 583. Thank you, Your Honors, for your attention. I now take it over to lead counsel. Okay, put this down.
Prior to my appointment, these hearings had been scheduled for October of 2024. For a number of reasons, those hearing dates had to be vacated, And in December 2024, this chamber unilaterally set the present date. I'd like to dispel the myth that the hearings were delayed by 11 months because I asked for that. In fact, when invited to do so, the defence made no arguments at all as to when these hearings should take place and would have participated whenever the court scheduled them. Nonetheless, the defence makes no complaint about the amount of time it has in fact had to consider the material. Between us, we, the defence team, have read and assimilated the 11,000 odd documents disclosed over the course of the last year, and where relevant sent inquiries, requests and challenges to the prosecution throughout. Similarly, we've scrutinised the document containing the charges and the pre-confirmation brief. The highly experienced and, dare I say, extremely clever team of lawyers I have assembled is bursting to tell you that the charges, or at least some of them, are formally impermissible or legally incorrect. And, having reviewed the evidence, they're just as anxious that the lacunae in some of the foundational evidence is also highlighted. However, running alongside what might be termed normal case preparation has been the nagging uncertainty of what our professional responsibilities are in this unprecedented situation for counsel and a defence legal team. This is a very experienced team which can draw upon practical backgrounds in 5 separate national jurisdictions and every single one of the international tribunals. But still, for all of us, this is a novel situation. The same soul-searching questions dogged our every decision along the way. Namely, what exactly can a defence lawyer argue without instructions? And what is in Joseph Kony's best interests? Can we assume that he would even wish to contest the confirmation of charges against him? Might he not prefer to waive any challenge and keep his powder dry for trial, or even to plead guilty? How would we be serving his interests by advancing even the most obviously meritorious arguments as to the form of the charges, when one, indeed probably the most likely outcome of any such challenge, would be an adjournment to permit the prosecution to amend accordingly, thereby tightening and strengthening the case against him? How would it be in his interests to point to fundamental flaws in the prosecution's linkage evidence, if that would only serve as a tutorial for its investigators, again prejudicing his position for any possible rerun of this confirmation of charges or at trial? How can we challenge evidence without instructions as to his likely plea or his comments as to whether he accepted or challenged the evidence in the first place? And then again, there is the ancillary point of how such an approach would be strategically consistent with the stance we have previously taken as to these proceedings, and our concurrent reluctance to appear to provide a template or precedent for how such proceedings might be conducted in the future. Thus, in due course, you may find our submissions will be limited to issues of process and remedy, which we are comfortable fall within our professional and ethical mandate and cause no prejudice, real or potential, to the absent Joseph Kony. On this, we will expand in due course in our submissions. Thank you very much.
Thank you very much, counsels. Yes, right. Very well then. We do have some time so that the prosecution can begin their submissions on the merits until 1 p.m. and then we will continue after lunch. All right then, prosecution, you have the floor.
Madam President, Your Honors, my name is Leonie von Braun, and I will begin the prosecution's merit presentations now. Our submissions by the prosecution team will follow mainly in the order of our document containing the charges, with a few exceptions, as you will see. I, for my part, in the following half hour, will deal with the question why we have charged Mr. Kony pursuant to Article 25(3)(a) as an indirect co-perpetrator, relevant to counts 1 to 29, and in the alternative for ordering and inducing these crimes. One moment, please. I'm not sure whether our presentation is on the screen.
Now it is.
Yeah?
That screen is off.
Okay.
Yes.
Evidence
Apologies.
channel 2.
Apologies, yeah. So just to recap very briefly, counts 1 to 14 relate to 7 attacks on IDP camps and the attack on the Lawala Girls' School. Counts 15 to 29 relate to the systemic crimes against women and children. In turn, today and tomorrow, my colleagues will address the evidence underpinning these charged crimes as executed by LRA fighters. Finally, our merits presentation will conclude by trial lawyer Henderson with the charges on individual perpetration of crimes. Now, Your Honors, let's look at the LRA. Mr. Kony and LRA commanders could rely for the obedience in the execution of their orders to commit the charged crimes on a reliable pool of persons, the LRA fighters under their control. Kony used the LRA to subjugate the will of its fighters who executed the crimes. The LRA fighters functioned as tools, and accordingly, Your Honors, their conduct is attributable to Mr. Kony. The evidence shows that he was the uncontested leader of the LRA. Witnesses with knowledge of the internal structure refer to him variously as the overall leader, chairman, president, chief commander. I refer Your Honors to the references cited at footnote 7 of our brief. For instance, UGA OTP 01500063 at paragraph 12. Further, Mr. Kony shared a common plan with his second-in-command, Vincent O.T., and other LRA commanders. And what is it these men wanted to achieve? As demonstrated by the sequence of events charged in this case, the LRA co-perpetrators wanted to attack civilians in northern Uganda, whom they perceived as their enemies, because they believed them to support the government a government the LRA was at war with. But they also wanted to sustain the LRA, including by abducting thousands of women and children. The charged crimes were all executed through the organized and hierarchical apparatus of power that was the LRA. Control Altar was a governing body and a type of LRA headquarters. It included posts like Army Commander, Deputy Army Commander, Chief of Staff. Those who operated LRA radio communications were also stationed there. There were 4 brigades: Sinia, Stokri, Gilva, and Trinkle, each led by a commander. The brigades were further divided into battalions, each equally led by a commander, and then further into companies known as KOIs. From September 2003 onwards, Mr. Kony created a division called JOGO. In the charged period, the LRA numbers fluctuated, but the system of abduction ensured that there were always sufficient numbers of fungible individuals to support a core fighting group of at least hundreds of fighters. And I refer you to the evidence provided by P455 at UGA OTP 0000-865, pages 7 to 10. Now let's look at the men within this hierarchy more specifically, those who commanded this hierarchy. Throughout the charged period, Kony remained the uncontested leader. Vincent O.T. was his deputy and vice chairman. He died November 2007. The command of the brigades changed over time by reason of promotion, demotion, opportunity, or death. Let us have a look at the individual brigade commanders now in turn. Until his death in late 2003, Charles Tabouleh was first in charge of Stokri Brigade and then became division commander. The prosecution alleges that Kony coordinated with Tabouleh on the abduction of the schoolgirls from Lawala Girls' School in June 2003. Buk Abudema was brigade commander of Gilva Brigade, then Sinia, then Stokri Brigade, then division commander. The prosecution alleges in particular his involvement in the attack on the Abok IDP camp. Dominique Ongwen, the convicted co-perpetrator, succeeded Abudema as brigade commander of Sinia Brigade. He was promoted by Mr. Kony on 4th March 2004, and I refer you to UGA OTP 0061 0002 at 0122. Ochan Bunya was brigade commander of Gilva. Charles Capera was in charge of Stokri Brigade, Sinia, and then Trinkle Brigade. The prosecution also alleges his involvement in the Lawala attack. Okoto Diambo was the commander of Trinkle Brigade, then Stokri Brigade, Gilva, and then he rose to Deputy Army Commander and Army Commander. Lakati was a Major General in Sinia Brigade. He then served as Deputy Chief of Staff and then Chief of Staff. And the prosecution alleges his involvement, for instance, in the attack on Pajula IDP camp. But he was also involved in weapons distribution for Mr. Kony. UGA OTP 00000865, pages 1 to 5. Jimmy Ochiti was a colonel and chief of personnel in Control Altar. Nyeko Yadin was a chief of staff and army commander until his death in 2004. And finally, Your Honors, Raska Lukuya is counted by the prosecution among the LRA's top commanders. He consistently held high-ranking positions as deputy army commander and army commander within the LRA. For the duration of the period charged, it was at least this group of men who collaborated with Mr. Kony, acting under his command, to use the organized and hierarchical apparatus of power as a means to control those fighters who executed the charged crimes, subjugating LRA fighters to their will. For the evidence on each commander and his role, I refer you to footnotes 9 to 19 of our pre-confirmation brief, more specifically. Your Honors, up to 4 times daily, these commanders would connect with Mr. Kony via LRA radio and report to him. And we have collected these communications, and they are evidence in these proceedings. They also met Mr. Kony either in Uganda or the Sudan. Insider witnesses, whose statements are before you, explain that Mr. Kony issued orders through Vincent O.T., who would pass them down to the brigade commanders. They, in turn, would implement through their fighters assigned to the brigades. Their descriptions overlap consistently, each describing similar behaviors over the charged period. Their descriptions are corroborated by intercepted radio communications, as summarized in paragraph 12 to 13 of our brief. Now, Your Honors, Mr. Kony also exercised control over the charged crimes in counts 1 to 29 by virtue of his essential contributions. All his essential contributions are directly linked to the attacks on the IDP camps, the abduction and enslavement of people, and the use of children in hostilities. The evidence is clear on this link. Throughout the charged period, Mr. Kony regularly issued orders to LRA commanders to attack, kill, mistreat civilians. And these orders, they translated into actual attacks. By virtue of the grasp Mr. Kony and his commanders held on the LRA, these orders were implemented. Kony felt unsupported by civilians in northern Uganda. One such example demonstrating his internal thinking is an example from a logbook of the early charging period in October 2002, of which there are many in the collection. Kony calls Acholi stupid. He wishes all of them are killed. He mentions that the LRA will produce a new Acholi tribe, which will be much better than the present one. He orders the LRA to start waging havoc, and that only LRA remain in Acholi land. UGA OTP 0068 00002 at 0058. Witness P138 describes attacks on civilians in Iteso as a response to the establishment of local defense units and Kony's resentment against civilians who had moved to IDP camps. UGA OTP 0000607, page 22 and 25. I will now set out a few examples of such orders to kill civilians. The underlying evidence of these orders is summarized at paragraph 18 of our confirmation brief. The first examples are from early to late 2002. Among them is an order to start serious killing the people across northern Uganda. This conduct continues in 2003. For instance, Mr. Kony instructs OT to attack Gulu, Kitgum, Lira, and Pader. Still in 2003, Kony begins to target also the Lango and Iteso regions more specifically. He instructs schools and universities to be attacked and students killed. Commanders are to hit Lango areas mercilessly and then proceed to Teso. On account of such orders to Tabule and Oti, the Lawala Girls' School is attacked on 24th June 2003. You will hear more of this later on today. Pajule IDP camp is attacked on 10th October 2003. My colleague will address that later on today. The orders continue, and so do the LRA's attacks throughout 2003 and 2004. I wish to concentrate a moment on Mr. Kony's actions in relation to the Abia attack on 24th February 2004, which is emblematic of his criminal behavior. Prior to the attack, Mr. Kony reiterated his orders to attack and kill civilians. On 23rd January 2004, he is recorded to have said, and I quote from the logbook, "Let Odhiambo go and kill Langi tribes from the old to the kids." UGA OTP 0254 4143 at 4208 4209. Okot Odhiambo, Stockery Brigade Commander, then instructed his subordinates to proceed to Abia IDP camp and to kill everyone there, both soldiers and civilians, to burn the houses, including with people inside. And that is what they did. Kony was so pleased with Odhiambo that he ordered him to conduct an even larger attack. I refer you to several logbook entries. For example, UGA OTP 0061002 at 0047, or UGA OTP 02427309 at 7364, as well as the testimony and statements of several LRA insiders, which we have summarized at footnotes 252 to 254 of our brief. 3 weeks later, Your Honors, the LRA attack Barlonio IDP camp and kill over 300 people there. After this attack, Odhiambo reports back to Kony, like he's done previously, like he's used to doing, around 23rd February 2004. He says to Kony, "The deaths were overly many. No living thing could be seen there." UGA OTP 0132 0026 at 0040 0044. On 13th March 2004, Mr. Kony promotes Odhiambo from colonel to brigadier. The LRA attacks continue pursuant to Mr. Kony's orders and result in killing, pillaging, enslavement at the charged attacks of Odek, Pagak, Lukodi, and a book. But Mr. Kony's essential contributions do not stop there. The evidence demonstrates that the LRA, under his authority and under his directions, abducted thousands of civilians. P71 explains that the order issued by Kony was to recruit civilians to join the army, and that this was a standing order. UGA OTP 0228-3708, pages 3730 to 3733. A demographic analysis of data of returnees resulted in a count of almost 11,000 abducted persons. On your screens, you find an excerpt of the results of the otherwise confidential report. The data is sourced from UGA OTP 00001133, page 3. Among the registered abductions, 22.6% were women and girls, and 77.4% were men and boys. This data supports the allegation on how one of the main aims of Kony was to abduct, to recruit fighters. Even more importantly, the data shows that 56.5% of the abductees were below 18 years old. This supports the assertion that Mr. Kony's aim was to sustain the LRA as a fighting force by creating an army of children. However, please note, Your Honors, that these figures are conservative. Only about 43% of all abducted children were actually registered. The actual numbers are most likely much higher. UGA OTP 00000942, page 3. And Mr. Kony also issued orders to abduct women. Insider witness P0233 testified that abductions of girls occurred habitually based on Mr. Kony's orders. UGA OTP 00000603, page 46. P205 testified that in 2002, prior to an operation, Kony issued an order to abduct beautiful girls, stating that, and I quote, "Whoever did not have a wife was going to get a wife." UGA OTP 00000657, pages 20 to 21. In this entry of 12th May 2003, Kony instructed his commanders that now they should seriously embark on abduction, that what he wants now is that many schoolgirls should be abducted and brought in the bush because they will help them as wives. For the record, UGA OTP 0068-0146 at 0161. Children, both girls and boys under the age of 18, were also systematically abducted. In a police report of intercepted radio communications from 6 May 2004, Mr. Kony ordered Vincent Oti and Raska Lukuya to abduct many children to replace escapees and defectors. And Lukuya answered that he will. UGA OTP 0017-0187 at 0189. Insider witness P70 testified that the standing orders concerned children who could walk, who could help you carry luggage, who could be trained to be fighters, age 10 and above. UGA OTP 0000598, page 28. Insider witnesses describe how Mr. Kony devised and enforced the rules governing the mistreatment of abducted women and girls. For instance, young girls were first made babysitters called Ting Ting, and matured girls were forced to become wives. My colleague, Ms. Sanyu Ndegira, will today present the details on this and how this was implemented in practice. Kony also decided on the distribution of abducted women within the LRA. In a logbook entry of June 2003 from UGA OTP 0068 0146 at 0229, which appears on your screen, Mr. Kony gives precise instructions to an LRA fighter named Angola. Angola should give one lady to OT, keep one for himself, and then he instructs Angola to attack seriously in abducting more schoolgirls to replace their old women. P138, a former LRA member, and I quote from his transcript here now at UGA OTP 0000607, page 28 to 29. If you refuse to go to a particular husband, that means that you do not want to live. That means that you will be killed, and you will be killed immediately. So you make the decision. Do I want to live or do I want to die? And Your Honors, Mr. Kony led by example. The evidence shows that he made abducted children into his own escorts. I refer you to P23 at UGA OTP 01500063 at 0066 and 0070. Witnesses describe that he forced many women to become his wives. We have summarized this evidence at paragraph 56 of our brief, but you will hear more about the extent of this practice later on today. Mr. Kony and LRA commanders exercise control through a violent disciplinary system, implemented especially against low-ranking LRA members. Punishments for breaking LRA rules were immediate and brutal. They included beating, whipping, stabbing. And again, low-ranking LRA members were, in general, abducted children. The punishment for trying to escape was often death. P172 testified that Kony himself would tell them, "If you try to escape, I will kill you." The witness states that Kony would have his informants everywhere in the LRA, and that's why everyone was scared. UGA OTP 0000962, pages 12 to 13. The punishments extended to the abducted children. They were subjected to excruciating beatings, sometimes for little else than dropping food. Kony issued orders on military attacks and operations. For instance, he ordered the Teso campaigns and put OT in charge. UGA OTP 0208-0146 at 0152. According to insider witnesses, he made orders on where to move on the front line via the radio, and then details were left to OT to communicate. UGA OTP 0220-0068 at 0074. Kony was promoting and demoting commanders. I gave the example of Odhiambo today, but there are other examples throughout our evidence. Logbook entries across the charge period show how the LRA commanders reported their loot from operations, including weapons, to each other and to Mr. Kony via radio regularly, and that Mr. Kony then weighed in on the distributions. An example is UGA OTP 0232-0234 at 244. Your Honors, when looking holistically at the evidence, there can't be any doubt. Mr. Kony commanded the LRA. He and his co-perpetrators used the apparatus of power that was the LRA to control their fighters, subjugating them to their will, and he exercised control by virtue of his own essential contributions, not only to the common plan, its implementation, but to the crimes. Kony acted with intent and knowledge, which you can see from his own statements, some of which we have presented here today. But overall, his conduct is also of such a nature that it could only have been undertaken intentionally. And this concludes my presentation, first part of the prosecution's presentation on the merits. And I thank you very kindly for your attention, and we shall move into the break then now.
Thank you, Counsel. All right, so it is a minute or two before 1. We deem it to be 1 o'clock, and we shall be back at 2:30. Someone correct me if I'm wrong. It's okay, yes, all right. So 2:30, right, when we shall continue hearing the prosecution case on its merits. All right then.
Rise, we agree.